Stone, there has been some indication that the prosecution has some evidence about motive. That there was some indication that Don Marangelo was a compulsive gambler or a problem gambler,
right,
and that this was an issue with Fern, and that among other things could have had something to do with this. Now, how important do you think it is, if that's what they're going to go into, to come up with some sort of, it seems to me they don't need much of a motive here. You know this was a contentious marriage, you know that they argued a lot, and that she particularly was volatile, even though he didn't seem to be. How important is it for them to come up with some sort of motive?
Well, motive technically you don't ever have to prove in a criminal trial, but if you have a defendant who is well educated, very successful in his business, doesn't have a long criminal history, somewhat of a pillar of the community, and he's a geeky type of, he's an aeronautical engineer, you really need a motive, or you're going to leave the jury wondering, well, why would he kill his wife? I mean, normal people just don't kill their wives unless there's something underlying all of that. There's been some evidence that they fought a little bit, but there's also been evidence from the next door neighbors who went with them to Italy for 3 weeks, and they said that they had a perfect marriage, that they never fought, they never saw them raise their voices to each other. They seem to be a very loving couple to each other. So I think the prosecution needs something to show this jury that this person could have been pushed to a point that he actually committed murder. Otherwise, just couples bickering over everyday stuff is not necessarily rising to the level of how a murder comes about.
Don't you think the prosecution can make a strong case if they can refocus for the jury the fact that here is a man who, first of all, he doesn't seem to be concerned when his wife goes missing. There, in his own house, are flyers. The police have found a body in the bay, and does anyone know who this body might be, the identity of this? But he doesn't call the police or do anything. And it turns out later that she was killed with his gun, which was found right off the end of the dock behind his house in the bay. And they have 2 tape recordings in which he tells 2 different people, his son and his niece, that that gun was thrown away some years before.
I think you have 2 things going on here. The strongest piece of evidence clearly for the prosecution is this timeline element. I mean, this is a man, it's unreasonable or surprising or unusual for someone to wait almost a month before reporting your missing wife to the police, and you're more concerned about lawyering up first and getting advice from your attorneys than you are about finding your wife. That's the toughest thing for the defense. However, the flip side of that is the gun's found off right 300 feet from his house, and so is the body. The prosecution on the one side, they're arguing that this is a meticulous person. He cleaned up after this crime. He made sure all of the evidence disappeared. You can't find any credit card receipts, nothing that shows where he purchased all these cleaning materials, no evidence inside the house really to speak of. Yet at the same time, he was dumb enough to take the gun registered to him and toss it right off his own dock. I mean, I think that it contradicts itself in his own theory. So the prosecution has that to contend with, but they have a very strong case with the timeline if they would just focus on it.
Okay, we don't know whether or not they're going to. There was a little bit of that we didn't hear from. Stone, for the most part, it's predictable. The judge went a little bit into his background to show that he is a person that's done some accomplishments in his life, and so he has the kind of mentality where he can make important decisions like this. And he has good counsel, and he's decided not to testify this time.
Right, and this is pretty typical, pretty standard to do, to ask the defendant to make sure he understands his rights, that he knows that if he doesn't testify now, he can't come back later and try and argue that he should have been allowed to testify, that he wasn't quite aware of his constitutional right to testify on his own behalf. And that's just for the appellate record to make sure that there's not an ineffective assistant of counsel argument made later.
And I take it that you sort of agree with the decision, although he did testify in the first trial. Apparently his testimony was well enough received because the jury voted 5-1 to acquit him and then deadlocked at that point. You seem to go along with the decision that even though he did all right the first time around, maybe they think they've got it made.
It's always a tough decision, and it's always a gamble when you put your own client on the stand, regardless of how educated he is or how savvy he is, because you don't know what he's going to say, and you don't know how the jury is going to react to him, and what the prosecution and how successful their cross is going to be. In this particular case, we already know that his testimony was successful in the first trial. They didn't bring the jailhouse snitches, so to speak, from the first trial into this trial to say that he confessed in jail, which they did the first time. And they had the momentum from the very beginning, from the very first witness. They had their other suspect evidence, the Doug Morangello, that he possibly could have committed this crime. They don't need to prove that Doug did it. They only need to show that it's possible, and that's enough for reasonable doubt. So,
what do you make of the fact that here you had 5 of the 6 jurors who voted to acquit him, and yet he has spent all this time in jail, not being granted bond, between that trial and this one?
Yeah, we talked about that in the break, too. I'm surprised by that. I mean, under the Constitution, under the bail laws and constitutional principles, you can be held without bond, or your bond is based upon two arguments. One, that you are a flight risk, and 2, that you are a danger to the community. Even under the prosecution's own theory of this case, this argument escalated into a murder. It's not even first-degree murder, it's second-degree murder. So I don't think there's really a danger that he's going to go out to the community and kill more people if that's what they're concerned with. And as far as the flight risk is concerned, he's a wealthy man. He could leave the country, but there are less restrictive means that they could use. They could put him on house arrest. They can take away his passport. They can make a $3 million bond.
Well, maybe it suggests that the judge in the first case looked at the evidence and thought maybe he did this. Right. What's happened is that there have been some disclosures in the courtroom there while we were on a break, and we didn't get all of them to you yet. Gene Casares is now in position to help us with that. Gene, apparently, while they're waiting for the jury to come back, if that's what it's all about, Stone, they apparently are going to be told, the jury, that here are these documents from Winn-Dixie, and the way it's done, they'll, rather than read them to them, they'll just let them have them when they, if they're entered into evidence, when they go in to deliberate. But I would think that it would be almost the most unprobative evidence that the prosecution could submit.
Yeah, and I actually think that that's probably going to help the defense to some degree, because what they're going to tell the jury is that the keys that are found in the house, that they contacted Winn-Dixie because there's this little shopper card, and that they can't tell who actually opened that account, therefore they can't tell who owns that little shopper card, therefore they can't tell if those keys belong to Don Morangello or his wife Fern Morangello. And if they can't do that, the defense gets to stand up in closing and tell the jury they can't even tell you that those keys don't belong to Don himself. They have to prove their case. They have the burden. We don't have to prove that they did belong to Don. They have to prove that they did not, and they can't even do that, and they even showed you that they can't do that. That's reasonable doubt.
How does the defense get itself into the kind of predicament they did this morning? We just heard from Gene Casares, and we heard the judge allude to it, but he didn't give specifics, that apparently over the late yesterday, the defense got some information, and that it was wanted to present it to the jury, but didn't tell the prosecution until the jury was moving into the box. And so the judge says, I'm not going to let you present whatever this is because it wasn't timely.
Right.
How do they get themselves into a squeeze like that?
You know, that's clearly a mistake. That's just two adversaries that are going at each other trying to win. I mean, you are first and foremost an officer of the court, and what the defense should have done is they should have contacted. They didn't have to contact him last night, but they could have contacted him early this morning. You have to give the other side a fair opportunity to respond to whatever evidence you have so that they're not surprised and sandbagged. And I think that's what the judge is saying, is that you know, if you do that at your own peril, and I'm not going to allow you to take that unfair advantage of the other side.
All right, now the judge and the lawyers are doing something that viewers of Court TV will be very familiar with at this stage of a trial, and that is they're beginning to talk about the instructions that the judge will read to the jury. So let's listen to what those are likely to be.
Defendant's statements.
Our time with you is about to run out. I want to thank Stone Grissom for being with us. Stone, we hope that you will give up your practice in Tacoma, Washington, and in Columbia, Missouri, and move here to New York so you can join us again, be our guest again.
Well, it's been my pleasure.
Enjoyed being with you, and we appreciate you shedding some light on some of the things that happened this morning. But